An anger management course might help. Jim Jordan, are you going to sit there and take this, man? You're in Congress. You run the Judiciary Committee, and then lied about in letters when the court was inquiring, and then called Ashley Merchant a liar and tried to smear her and have her sanctioned while you guys were covering up your affair. Wasn't honest at all. Fani Willis takes this up in conclusion, says, bring back these charges. Fani Willis is now trying to appeal Trump's dismissal of his charges. Remember that Judge McAfee got rid of 6 counts from Fani's terribly drafted indictment because the judge said Trump doesn't even know what they say. Yes, he got charged with crimes, but what are the crimes? It's so poorly drafted that Trump doesn't have proper notice to defend himself, and so those charges went bye-bye. Now Fani is appealing this in the state of Georgia because she wants those charges back. Now we'll go through it. It's a technical filing, and we'll see what her arguments are, and we'll see what the Court of Appeals does. None of this is going to happen before the election, and after the election, after Trump wins, arguably, we'll see if it happens then. But we'll come back on this because there's other Fani Willis drama. Trump's lawyer came out and he said the following. He's noticing something that's happening there in Georgia. What could it be? Corruption? We'll see. He says, here, just a brief musing, now that the media is reporting that Fani and Wade are sharing the same personal attorney, which is interesting because they're not married, they're kind of trying to create some sort of a privilege there, like marital privilege or spousal privilege or attorney-client privilege because we have the same lawyer, and every time we talk, we're talking about the case or whatever. They can claim all of their communications are confidential and privileged. Now, all protected by their lawyer. Here is what Steve Sadow says. How very convenient. And it is convenient, isn't it? And do you know who their lawyer is? Guess who? Roy Barnes. This guy that we saw testified in Georgia on behalf of Fani Willis came out there and said everything was basically above board. And how do we know he's representing Fani and presumably Nathan Wade? Well, because he wrote a letter to Jim Jordan, and he sent it, as you can see. He says, hey, dear Jim Jordan, remember Jordan sent Fani Willis a letter and said, I want all this information about your disgusting corruption and your noxious odors. And she scolded him back and said, I'm not giving you anything. You're Congress. What do you think? You have power or something? You're useless. She's kind of right in many ways. But now Barnes Law Group sent this one, not Robert Barnes. He's great. Now this one is from to Honorable Chairman Jordan. It says, all right, listen, Jordan, I've reviewed your letter that was addressed to Nathan Wade. And though my client and I were discussed in the letter, I was not sent a copy. And so I thus obtained the same through public sources. Now I find the tone of your letter there, Jim, to be filled with vitriol and anger. And I would suggest you take some deep breaths and calm down. So this matter may be discussed without emotion. An anger management course might help. Jim Jordan, are you going to sit there and take this, man? You're in Congress. You run the Judiciary Committee. Now, in regard in what capacity, I represent the Honorable Fani Willis. I represent Miss Willis in a personal capacity, as well as her capacity as Big Fani. Now, I insist on the procedures outlined in my earlier correspondence upon the examination of Mr. Wade. Now, I'm just a country lawyer, he says. Yeah, right. Unaware of the ways of Washington. It's a nice shtick. But I must comment on your statements regarding our obedience to subpoenas. I noticed you were served with a subpoena based on the illegitimate, this guy, is he really a lawyer? On January 6th insurrection. It was illegitimate, okay? There, Barnes, remember, H.R. 503 was utilized to authorize the creation of the House Committee. Guess what? They didn't follow their own rules in H.R. 503, not even close. So it's illegitimate. So why would Jim Jordan respond to Liz Cheney's subpoena? Idiotic, obviously. It's not even good law. Now, I therefore find your protestations regarding a normal citizen obeying subpoenas hollow. He's quoting the Bible and Jesus. Oh gosh. It reminds me of Matthew 7:3. Why do you see the speck that is in your brother's eye, but do not notice the log that is in your own eye? The South have a similar saying. This is like a skunk telling a possum his breath stinks. This guy, Roy Barnes. When you have calmed down and attended the anger management class, Jim, I will be glad to discuss this matter with you in logical, dispassionate manner. Dude, you're mocking him, okay? This is hypocritical. You're telling him that he needs anger management while you're mocking him and acting very unprofessionally, I'll say. Now, I wish you and the other members of Congress the very best in undertaking the work of the people. By the way, since we in Georgia just experienced a great tragedy, a school shooting by a young man with a machine gun, do you think you could take a short breath and solve that problem? Roy Barnes, counsel for Fani Willis in all capacities. He's a perfect lawyer for Fani because they're both unprofessional, just Democratic hacks, essentially, is what I can tell from this letter. So that is the lawyer who testified on behalf of Fani Willis. In my opinion, he was testifying on behalf of her. He would say he's a neutral witness, but he was very favorable to her. And now we can see why. She hired him. All right, so that's what's happening. Now he's representing both. Apparently, according to Steve Sadow, Nathan Wade and Fani Willis. And Nathan Wade showed up and gave his opening statement with the Judiciary Committee, and our friend Phil Holloway grabbed this one. He's also on YouTube and on X, and he does great great coverage. He says that Nathan Wade said the following, or something like the following, when he was there in front of Jim Jordan, who was just getting backhanded time and time again by the people in Georgia. They should be defunded, obviously, immediately. Now, good morning. He says, my name is Nathan Wade. Here we go. I'm a licensed attorney in good standing in the state of Georgia, which is a miracle because of the corruption. I am here after voluntarily accepting service of a subpoena from the House of Representatives. I am here of my own volition, having paid for my own flight tickets and hotel room with Georgia taxpayer dollars that he should have never gotten because he was hired corruptly in a conflict of interest with his lover. But anyways, he paid for it on his own, so that's good news. To respond to any legal relevant inquiries, please note all arrangements were made per agreement for my voluntarily testimony, but this committee changed the date for its convenience. So he's like, I had to come out of pocket to reschedule my flight, which is annoying. Now, you're aware, I served as Special Assistant DA with Big Fani. Prior to accepting that, I served as a prosecutor several times during my career in these various positions. I began my private practice in 2000. I served as a criminal defense attorney. I represented hundreds of individuals in state and federal courts with felony and misdemeanor charges, tried many felony cases, representing clients in serious matters, including but not limited to these crimes: capital offenses, murder, rape, armed robbery, aggravated assault, aka the Doug Emhoff, and drug trafficking, aka the Hunter Biden. Many of the cases garnered media attention. I have served as a civil attorney in private practicing representatives, individuals, and he's given no attention to partisan politics. I have previously been retained to represent a Republican sheriff. I served as legal counsel to the NAACP. Now, in 2010, I began serving as a municipal court judge, was proud to become the first African-American to do so in Marietta, Georgia. I was invited to assist in the training of newly appointed municipal court judges, and I got dozens of accolades. My team investigated the issues in the election interference case for more than 2 years. This case was not politically motivated. Yeah, okay. Now, rather, it was an independent investigation based upon facts and interviews. I had no mandate other than to honestly seek the truth, exclamation point, on your multiple cruises on taxpayer dollars that you hid from everybody and then lied about on your disclosure forms and then lied about in letters when the court was inquiring and then called Ashley Merchant a liar and tried to smear her and have her sanctioned while you guys were covering up your affair. Wasn't honest at all. And by the way, if he honestly sought the truth, then he wouldn't have brought the charges because there were no crimes here. And that would have resulted in this case being closed and his billables going to zero. So he had a financial motivation and a personal motivation to keep this case going. So honesty has been shattered by the conflicts that are riddled throughout. Then they lied to Judge McAfee to his face about it, which is a crime. I was never directed, ordered, asked, or coerced or pressured to bring any charges, obviously. Nobody needed to do that. That's why you were there. I took my oath as a prosecutor with solemn pride, blah, blah, blah. I did not violate the oath and did nothing to compromise the integrity of prosecution. Yeah, you did. I just detailed how. Not one at the White House or White House counsel's office, Jack Smith, or the DOJ or the J6 committee ever directed me to do anything against anyone, exclamation point. Due to the lack of cooperation from witnesses and other government officials, Fani requested permission to impanel a grand jury. They returned an exhaustive report. Following the recommendation, we launched an indictment. Several defendants moved to disqualify me and Fani. The trial court held a hearing. In March of this year, the motion to disqualify was denied. In its distasteful dicta, okay, he's talking about McAfee here, who said that Fani has a noxious odor. He's like, she smells great. The court opined that either I resign or Fani's office resign from the prosecution. Consequently, I voluntarily resigned. Since that date, I've had minimum contact with the office of Fani and have had no access to documents left there. So he's not talking to the office, but he's still hanging out with Fani. He showed up with Fani when her daughter got arrested for driving on a suspended license because of her criminal record. On May 9th, I received a letter from Jim to produce 6 categories of documents. I voluntarily complied with that request by producing the documents that I possessed, which of course were none. I had nothing responsive, there you go, to notes, memoranda, or communications because I left the office. I have nothing for you. I can't give you anything. The committee's purpose in requesting those documents and in seeking my appearance is talking about the money and federal funds, which they won't do crap about, so we'll just leave that there. The committee has also considered legislation broadening the existing statutory right of federal removal. And he says, well, okay, I'm here to cooperate with you, but contrary to any fabricated story that I somehow evaded service, I voluntarily reached out to Marshall's office to then meet them and get served. We don't appreciate the inflammatory media reports about me fleeing to Belize again. You are aware, and I am bound by the Georgia Rules of Professional Conduct responsibility and must at all times maintain in confidence all information gained in the attorney-client relationship. I've been served with the following letter, and he's going to read the letter into the record. Now, our friend Phil Holloway said, I'll add this, okay? These guys are labeled as special assistant attorney generals. They're not considered prosecutors, okay? They're like private lawyers who handle cases like in juvenile court. and other things. So kind of mirrors the federal statutes where the DOJ, get assistant attorneys to help with, tribal cases and stuff like that. So that's Nathan Wade. Very Nathan Wade letter. And he paid for everything on his own with Georgia taxpayer dollars, but at least he paid for everything on his own. All right. Now here you'll see Fani is also appealing the Trump charges, saying that they were perfectly specific, okay? That the indictment wasn't screwed up. In March, if you recall, we covered this, McAfee dismissed 6 charges, quashed them, said that Trump and others didn't have proper notice. One count against Mr. Trump was saying that he unlawfully solicited Raffensperger, the Secretary of State, to violate his oath. Now, the core of her case against Trump is January 6th, and it's going up on appeal. Other defendants are included. Back in March, Judge McAfee said prosecutors were not specific enough about which violations the defendants were pressuring public officials to commit. They do not give the defense enough information to intelligently prepare for trial. Office of Fani disputed that, and here's what they sent in. All right, Judge McAfee, you really screwed up here. When you got rid of these 6 counts, all right, my indictment, says Fani, more than sufficiently placed Trump and the defendants on notice of the conduct and allowed them to prepare an intelligent defense. The indictment included an abundance of context and factual allegations about these solicitations and to whom the requests were made. And so, McAfee, you made a mistake when you required the state to plead in the indictment enough details as to the target crime of the violation. What were they trying to do? That's not even required. They say solicitation is complete before the target crime even commences. For example, solicit prostitution without actually doing the Willis Wade. You know what I'm saying? So as a result, the target offense in an allegation of solicitation does not need to be as detailed as though it's actually a completed crime. The only Georgia case concerning the issue does not provide a clear analog. And so we provided enough details. There's plenty of particularity in there. And facts and context from all of the other counts of the indictment provide context for them as well. So even if we don't provide the details in the particular paragraph of the charge, right, these 6 charges, elsewhere, and it was a huge indictment. Remember, there were acts, tons of acts, and overt act, 137. So they say, we've done enough. And if it's not in there, in the specific paragraph, they can look elsewhere in the indictment. So the question is, of course, did the trial court, Judge McAfee, err by granting a dismissal of those charges? And Fani's going to say, yeah, he screwed up bigly. Says the indictment is sufficient to withstand special demurrer, which would be the quashing dismissal of the charges. The indictment set out 6 counts of solicitation of violation of oath by a public officer. Here's what they wrote. On the 3rd day of December, these guys unlawfully solicited certain public members, including unindicted co-conspirators and others, in willful intentional violation of the terms to engage in conduct. Okay, so they solicited them to engage in conduct to unlawfully appoint presidential electors. Same thing, charged Trump here. Count 6, charged Giuliani there. Count 23, charged this person here. And Meadows got charged there. Now, while this is timely, the test is whether it's constitutionally sufficient, and there were clearly alleged underlying facts here. There's an abundance of facts. And as observed by McAfee, there was only one oath that could be violated, so we know exactly what they're talking about. So they didn't need to go into the specificities of the oaths because they only have one. When read as a whole, the indictment provides extremely clear picture of what we're charging. Count 1 detailed the solicitations. We were talking about the Arizona House of Representatives. There was another oath that they had to take there that they're asking them to violate. And so in striking the solicitation counts and deleting them, the trial court made an improper comparison between inchoate crimes and compound crimes, which led it to seek excessive detail in the indictment. So we didn't need to put all that stuff in there. Solicitation has been described as the most inchoate of the anticipatory offenses because solicitation occurs so early in the criminal planning phase, its prohibitions furthers the purpose of the criminal law. And so the crime of solicitation is complete the moment the accused, with the requisite criminal intent, engages in the act. So it's not completed, right? The crime is not completed. You solicit a prostitute, then the cop busts you. That's solicitation of prostitution. Don't actually have to engage in the act. The solicitation may be complete well before the specific targets are done. And so by contrast, unlike solicitation, a compound offense necessarily depends entirely on the completion, and that's not what we're asking for here. So they are saying that we were indicting him, saying that the crime had been completed. That's not the intention of our indictment. Our intention was just to say it was solicitation, and so it was sufficient. Now, the only Georgia case concerning the level of detail necessary for solicitation is this case, and the judge is misinterpreting that case. Sanders should be distinguished here. here. There's an Alabama case that should be distinguished. The Seventh Circuit, they're talking about that one. Finally, the Northern District of Georgia upheld the sufficiency of an indictment for solicitation. And the indictment there, which was upheld, was kind of like ours. So ours is good too. None of the above indictment alleged how the target offense was to be performed, but was upheld as sufficient. And so you should say ours is sufficient as well. So Fani Willis takes this up in conclusion, says, bring back these charges. 2, 5, 6, 28, 36, 38. This is brought by Alex Burnick. Looks like a new player is entering the game on this. One of the appellate attorneys there trying to bring the charges back from Big Fani. And so, of course, we'll be here. We'll see what McAfee does, regardless of what happens with those charges, which I don't think are coming back. And I don't think Fani's going to stay on the case. I think this case is ultimately going to go bye-bye because Fani lied to the judges' faces. We'll see. But regardless, it's not happening before the election. So all of this, even this appeal, will now take months to process and develop. And we'll be here continuing to cover it.